Various academic and policy-related activities at sea primes, including lectures, discussion forums, and stakeholders interactions in maritime domain. Thank you, sir, for your continuing and guidance. Welcome. Most respected registrar, catalog examinations, and director, deans, heads, and faculty members, students, and deputy registrars, officers of IMU headquarters and various campuses who are joining us both in person and online for this important lecture. We sincerely seek your cooperation and active participation in making this event a great success. Once again, I extend very warm welcome to all of you for this. Now I invite our most respected Provisi sir to say a few. Dr. Chandramouli, the expert speaker for today. Honorable Vice Chancellor, Dr. Malini Shankar, colleagues, dear students, a very good morning to you and I welcome you all for today's talk. Sea crimes, we have been trying to ratchet the activities. This is one of those efforts that we have got Dr. Chandramouli here. Talk is an overrated means for dispute resolution. This is what Tom Cruise says. I want to hear more of it and other means of settling disputes. On that note, I hope that we all gain from this talk. Thank you. Thank you, sir. I'm happy to welcome our most honorable Vice Chancellor, Madam, to this.
Yes. Good morning, everybody. Today's expert speaker, my good friend Dr. Chandramouli, Pro Vice Chancellor Dr. Balaji, Registrar Mr. Saraman, the Controller of Examinations, Dr. Joshi, and all the Chennai Campus Director, and my dear students. Just 3 points. One is the Indian Maritime University, for the information of the speaker, used to have a course on maritime law. which was suspended, which was actually, went faded away. And we are in the process of reintroducing maritime law into the curriculum in the form of a diploma in maritime law, which is expected to start in the coming financial academic year. So,
He began his career in the Indian Public Police Service IPS 1983. Most respected Vice Chancellor, good friend and a dear colleague.
Conflicts whenever it arises. So maybe pave some mechanisms to solve that particular dispute or problem whenever it arises.
All of you see movies. Allora, Nata Bhattacharya. They'll sit under the banyan tree and then they'll give judgments. Two people will come. They will present their cases. There is a dispute, and these bunch or the Nata man will give the final decision. This is one way of resolving disputes. The other way is to go to the police or go to the court, launch an FIR, then they will investigate, then the courts will take their time to resolve your dispute. So like that, we have a regular system of resolving disputes by going to the courts. Whenever we have a problem, there's a contract, somebody has failed to go by the contract, or there is a problem in the interpretation of the contract, etc., we go to the civil court. The civil court then gives its own decision. After that, we have an appeal provision. If we are not happy, we go to the High Court. From High Court, we go to the Supreme Court. In Supreme Court, we then have benches. So this is the process by which disputes are resolved. But there is something word called alternate here. Now, what is that alternate? It is something which is not through the regular system of the courts, but through other means. And that is why it is called alternate dispute resolution. Many of you would have heard about Nyay Panchayats, right? So this is something like that, and we will talk today about what are the mechanisms which are available in the port sector, in the shipping sector. We are not going into the general sector, we are just talking about the shipping and maritime sector. You know who this is? Superman. So when you have a dispute, somebody calls it a bird, somebody says it's a plane, the third person is that arbitrator or the alternate dispute resolver who comes and actually resolves for you whether it's a plane or it's a bird or it is Superman. So that is what it is, a third person accepted by both of them who comes, listens to both the parties and gives finally a kind of a decision which is accepted by both. So in this lecture, we will first look at what is the importance of the shipping sector, how public-private partnerships have grown in the shipping sector, how important it is, what are the complexities of PPP, public-private partnership, what's the need for alternate dispute resolution mechanisms, which is basically what are the challenges of regular system of litigation, and what is the case for ADR. ADR, what are the methods, arbitration, mediation, and conciliation? What are the challenges in this alternate dispute resolution? We will, if time permits, take up a few case studies, and then what the government has done by way of forming a
Conciliation and Settlement Committee, how far it has succeeded, and what is the way forward. This is what we are going to cover during the course of this next 1 hour. All of you are aware you are going to join the shipping industry. It is the lifeline of our economic development. Handles over 90% of the country's international trade by volume and about 70% by value. India aspires to become a 5 trillion economy, and the maritime sector, particularly its major and non-major ports, play a pivotal role in facilitating global trade, enhancing supply chain efficiency, and attracting foreign investment. So this is the industry which you are going to join, a very, very vital and crucial industry, a sector which has many stakeholders, but basically this is the sector which is the lifeline of India's economy and our aspirations to become a global player in the world. Now here you have to understand that not everything can be done by the government. The government in the past used to be the sole player in this entire sector. They used to set up the infrastructure. They even had shipping lines, which were public sector undertakings. So we used to set up the ports, we had to set up the port. And therefore, government decided that the public-private partnership is a model which should be brought into not only the maritime sector, but also the infrastructure sector, roads, buildings, bridges. All this, government thought, why should we invest the money? Let us get the private people, form a partnership between the government and the private people, and ask them to take over, so that the investment is done by them. So now these PPP projects constitute the backbone of any capacity expansion in the infrastructure and modernization also. We don't have that much of money to invest, so we ask the private sector. There's a port, the equipment is old, cranes are old, or the new docks have to be created. We call for tenders, get experts to come in and who have the financial backing and give it out to them on certain terms and conditions. That is called the public-private partnership. Now it could be development operation of container terminals, cargo berths, transshipment hubs, dredging operations, multimodal logistical parks, port link, special economic zones. In the maritime sector, we are looking at PPP models for investments. It enables government to leverage private sector expertise, innovation, financing, while the private partner benefits from long-term operating rights and revenue sharing models. So this is basically what PPP is about. Any doubts on the PPP model before we go ahead? Okay. But these PPP projects are very complex. Every chance of, disputes arising at every stage. Because one, the scale of these operations are huge. Each of these investments will go into hundreds of crores. Secondly, duration. These contracts which are entered into are for long periods of time, 20 years, 30 years. That is the length of the contracts which we give. There are multiplicity of stakeholders in the PPP project. Port authorities, private concessionaires, shipping lines, custom agencies, logistics operators, all of them have to come together to make the project successful. And when there are so many players, there are bound to be some disputes among the various stakeholders. What are the types of disputes that can arise? One is there may be delays in project execution. There may be problems in interpreting the terms of the contract. There may be problems in understanding the revenue sharing mechanisms. There are some performance obligations. When we give a contract, we say, okay, you have to perform. You you meet these targets, very often they might not be able to reach those targets. So there may be problems of performance. There may be changes in law. Madras Port earlier used to handle different types of cargo, including, polluting cargo, like coal. Then we set up the Ennore port and we shifted the coal handling to the Ennore port. So here there may be problems. I had thought as a private player that so much of coal would come and I would make so much of profit. Now you have stopped coal here, you have shifted it there. So this could be some change of law, or there may be change in the tariff. There may be change in environmental clearances. And force majeure events. And what is force majeure? Force majeure is generally called an act of God. There was the COVID epidemic. Nobody knew that it would come. For 2 years almost, nothing happened in the country. But first was the lockdown. After that, it took time for the whole industry to recover. For almost 2 years, there was a slowdown in the entire economy, which could be predicted. So, or there could be pandemics or cyclones. Suddenly a cyclone hits and your whole industry is affected. So these events may also come up, but we may say, no, we don't care. It is written in the contract that you have to do this, these many tons you have to lift, or you have to handle so much of cargo over here. And we don't care whether there was a pandemic or whether there was a cyclone, you have to perform. So all these kinds of disputes arise when there is a PPP project. So what is the need for this ADR mechanism? Given that these public and private are involved, number one, there is a time sensitivity. Unless everything is done on that right time, you lead to losses. Traditional litigation, like I mentioned, first you go to the civil court, then it takes about 5-6 years to solve. You are not happy with it, then you go to the high court, again 5-10 years go there. Now, nobody can wait in the commercial side to wait for 15-20 years to get a resolution of your dispute. So it's time sensitive. So that is where the alternate dispute resolution mechanism, there are 3 major types of ADR. One is called the arbitration. We'll go into what is arbitration. Second is mediation, and third is conciliation. Now, these are the 3 main methods which we adopt as ADR in India. And this offers confidentiality, speed, cost effectiveness, and a more collaborative approach. We will go into that as we go further. I'd like you to look at this chart, which talks about our performance in the ease of doing business. This is a World Bank ranking of various countries and ease of doing business. Why, as an investor, as a foreign investor or an Indian investor, how easy it is for me to do business in India. This is what they are ranking different countries. And here, they have various parameters, difficulties in starting the business, dealing with construction permits, getting electricity, registering property. Like this, they have a number of things. And one of the things is enforcing contracts. And if you see here, out of the 186 countries studied, enforcing contracts, we are 163. Means our performance is extremely poor when it comes to enforcing contracts. We have made good progress in all other parameters, but when it comes to this enforcing contracts, it becomes a major bottleneck for investors to invest in India. Now, let's look at what are the challenges of traditional litigation. It is adversarial, which means we are fighting against each other. We are adversaries. What did we call the whole contract before? Partnership. We called it a public-private partnership. But when we go to the court, we become adversaries, us versus them. So it is time consuming, it is also expensive. Some estimates have shown that more than 5 crore cases are pending across Indian courts. And of this, infrastructure related disputes, which involve the government, can linger from 8 to 15 years. Now, as a businessman, do you have the time to wait for 8 to 15 years before your dispute is resolved? Obviously, no. The PPP cell of Ministry of Finance has noted that dispute resolution delays are a key contributor to stalled infrastructure projects. What does it mean? Because of these disputes, many projects they are left unfinished and the contractors just vanish. Because they don't have the luxury of waiting for 15 years to get that dispute resolved. This can raise the cost by almost 15 to 30%. Other estimates say that about 1.5% of India's GDP is lost because of these disputes. And project overruns due to unresolved disputes have cost India an estimated 4 lakh crores is what some estimates say. Ease of doing business I've already spoken about. But look at the average time which is taken to resolve a commercial dispute. It can be nearly 4 years before a simple dispute can be resolved in India through the courts. Now you know why the ADR is preferred, because it is a strategic alternative to litigation. It gives you speed. You can finish the entire case in about 6 to 8 months, or maximum if it's very complex and there is delay on the part of both parties, etc. It can be completed in 18 months. But compare that 5 to 10 years in the general courts, and you will see that ADR is a preferable alternative. Cost effective. Now, when you go to these 15 years, engaging top lawyers, engaging with law firms, it can be a very costly exercise. Whereas with this ADR, the costs come down because one, the time is very less and there are fixed costs. Confidentiality. When you go to the courts, many of the information you would not like to reveal. Government is very sensitive about data. They would not like to reveal certain things. In the ADR mechanisms, it can be kept confidential. Whereas everything that you, when you go to a court, you have to reveal everything. Flexibility. In courts, you have a certain procedure. You'll have to pay the fees. You'll have, then the hearing is set. Then the hearing maybe 6 months later, 1 year later, etc. But here, flexibility is there, where 2 or 3 arbitrators or conciliators can fix the time and allow a creative solution to the problem. Finally, it preserves the relationship. I said that when you go to the court, you are fighting against each other. Here, in ADR, you mutually accept, you give and take. Sometimes the government gives, sometimes the private party gives in the overall interest of the project. And you continue the partnership in the rest of the period. But when you go to the courts, you're fighting for a long period of time, your whole relationship gets spoiled. Let's see what is arbitration. Arbitration is a binding dispute resolution mechanism where a neutral third party, the arbitrator, renders a decision. Here it is a, note the words decision. Decision means I will hear this party, I will hear that party, and finally I will, on the merits of both the arguments, I will give a judgment, a decision. Now, which means that I have to accept one party, I have to reject the next party, and therefore one party will always be at a loss. And they will not be satisfied. They will again go back to the courts. So arbitration is quicker. The decisions come faster, but it is not a closure of that dispute. it leaves open further ground for appeal, further grounds to litigate. So many of our PPP projects, our agreements prescribe arbitration. The advantages are that it is legally binding, it is confidential and expert decision makers. But the limitations are that it is costlier than the other ADR options and there is no closure. This is arbitration. Second is a mediation. Many government contracts now say unless you finish mediation and conciliation, don't go for arbitration. Now, what does mediation mean? Again, is a voluntary, non-binding process where a neutral third party helps the disputing parties reach a settlement. I'm saying it is non-binding because the mediator brings both the parties together. In crude terms, it is a panchayat between the two parties. But unless they agree to sign a settlement agreement, mediation still leads to appeals. So mediation is something which is a good process. It has the benefits of speed, cost effectiveness. It is non-adversarial. It is confidential and adaptable. And many court cases, court sector disputes, they go in for mediation. There's no doubt about it. Now let's come to conciliation. Conciliation is just like mediation. Again, a third party, neutral party is selected and they go into the disputes, but they make both the parties agree and sign a settlement agreement. Once you have signed a settlement agreement, it means you cannot go for further appeal. You are accepting and signing. So this becomes binding and closed. And this has the legal status of an arbitral award. More and more infrastructure departments have set up these conciliation committees. In highways, they have set up several conciliation committees. Ministry of Ports, Shipping and Waterways has set up. Electricity Department, Power Ministry has set up. So they say instead of going to the courts, first go through ADR. If that fails, then go to the court. So what are the challenges to it? Many of us bureaucrats who are in the government, we resist such a mechanism because we are unfamiliar. We think that the best and safest way is to go to the courts. We have very deep pockets. Doesn't affect us if the courts take 15 years for them to resolve the dispute. So one is there is resistance from us. The parties are also reluctant because they are not aware of this process. So that is the first challenge. Perceived lack of neutrality because the government has set up this conciliation committee. The private parties feel that okay, probably they will always rule in favor of the government. They have this problem of accepting the credibility of the arbitrators or the conciliators. And thirdly, we have a lack of trained mediators and conciliators with maritime expertise. In the highway sector, you always have a huge pool of retired chief engineers who are ready to become arbitrators, who have domain knowledge in the field of. But in the maritime sector, we find very few people who come forward to become conciliators, arbitrators, or mediators. I think we need to spread awareness and train them so that they come into the field of arbitration. What we recommend or I recommend as best practice would be to include ADR clauses in all port-related government contracts, establish sector-specific panels under the Indian Ports Association, train conciliators in maritime, PPP, and infrastructure law, and that would be a suggestion which the IMU can take up. Ensure independence and transparency in selection of neutral conciliators. That is for the government to do when they set up a conciliation panel or an arbitration panel. They should ensure that people are neutral, and if they are found not neutral, then action should be taken to remove them. Let's see a case study. A private terminal operator has failed to meet traffic throughput targets for 2 years. The reasons cited include force majeure events, COVID-19 disruptions, and cyclone damage. The Port Authority insists on enforcing penalties as per the concession agreement. Meanwhile, litigation may delay expansion plans which are vital to both parties. This is the case. Please think over this case, and I want you to tell me which is the best way to go forward. You understood the problem? There was this contractor in a government port. He could not meet the target for 2 years. And he said why he did not meet it? Because there was this COVID, there was lockdown one. In the meantime, there was also a cyclone. Okay. But the port says nothing doing. You have signed a contract. In the contract, it says you have to clear so many tons, metric tons a day or so many tons a year. You have not met it, and therefore I will impose penalties on you. This is the case. What would you do in such a case? I think put on your thinking caps now and let us see. What do you think we should do in such a case? Anyone?
Some of the facts are very obvious in this case because we can go in for a conciliation. As one of the options, because there are three aspects which are staring at us. One is these three aspects are beyond the control of both the parties.
Correct.
That is the
COVID
COVID
was
pandemic.
beyond the party's control. Cyclone was beyond, and therefore, sir suggests that let us go in for an ADR
And
instead of going to the courts. Why we won't go to the courts, sir?
Yeah, I also feel, sir, it's a simple case as far as the law speaks.
Yeah, but why would we not go to the courts?
No,
I think students will answer that.
enforcing authority to ensure penalty is not correct because there is a force majeure.
Correct.
First, whether their contract has a clause for this forcing nature or not. That also.
That is fine. Yes. So let's see. I have decided not to go for court. Why?
Please get up and
Because it will take 10 to
Speak your
15
mind.
years.
it's an interesting topic.
My contract is only for 30 years, and if 15 years go in the court, I will be, what do you call, voting. And so I will not take up the court. So I will go for alternate. Let's see, why shouldn't I go for arbitration? The pros of going in for arbitration is number one, it is binding. There is a neutral third party. It suits such high stake contractual disputes. That is the pro. On the other side, it can be expensive. It can be time consuming. Arbitration is also more time consuming. It is adversarial in nature and may strain the relation between the parties. Outcome is zero sum. What do I mean by zero sum? One party will win in an arbitration, the other party will lose in an arbitration. And therefore, it will not satisfy both the parties. One party is bound to go, the party who loses is bound to go to the higher forums. So no closure. So in this particular case, it is less suitable than other means of alternate dispute resolution. So I say I will not go for arbitration. We can go for mediation in this case. But here again, unless both the parties are willing to sign an agreement after the mediator, resolves the dispute between them, it is not enforceable. It also has the other pros that it is preserving the business relationship, it's flexible, it's informal, it's confidential and faster than litigation. However, outcome depends entirely on parties' willingness to compromise. Unless one party is saying that I will give up so and so. Yes, government agrees that there was force majeure and that it gives up its right to put the penalty, it can never come to fruition. And unless both the parties sign, it cannot be completed. Now, here a major thing between mediation is that mediator cannot go beyond the two parties' presentations. Mediator can only listen to both the parties and the contract and give a solution, but cannot suggest a solution of its own. So therefore, this is also good for open dialogue, but since it involves interpretation of the legal contract and has a significant financial impact, its non-binding nature may not reassure the public entity. So let's come to conciliation. Conciliation is a third-party neutral solution. It is legally backed under Arbitration and Conciliation Act 1996. Settlement agreement is enforceable like an arbitral award. It preserves relationship by allowing pragmatic settlement and confidential, quicker and less costly than arbitration. But on the other hand, it relies on parties accepting the proposed solution. And there are power imbalances. That is, on one side is the government, other side may be a very small contractor. The government will always be stronger and will be able to put their views more forcefully than the private contractor. But in this particular case, it becomes suitable as it combines neutrality, enforceability, and collaborative problem solving. The conciliator can factor in force majeure, national disruptions, and broader public interests and suggest a middle path, which may suggest a partial waiver or a staggered penalty or revised performance benchmarks. So it balances the legal enforceability with the relationship preservation. It allows for nuanced solutions and it supports long-term collaboration and enables continuity. Like I can say, you call both the parties, tell them, look, government will go on appeal, will go to the higher forums, you will never get the money. If you settle now, maybe today you'll get some money. So this is possible in a conciliation. We can tell the court, look, this is a partnership. If he fails, you also fail. Your whole purpose of your port development will get affected. So we bring them to the table and tell them, okay, this is the impact on the national economy. After all, he did not have a role in this. It was not his performance failure. So the conciliator can talk to them, bring them on a neutral ground, make them agree to a solution, and make them sign a settlement agreement saying, okay, this is the full and final settlement. I will not go further on appeal on this case. Let us finish this matter here and continue with our partners. Therefore, in this case study, we decide mutually to give up certain things, take certain things, and finish the dispute once for all. And therefore, conciliation seems to be a very, very effective method of solving disputes of this nature, where you have to go beyond contracts. You have to look at the national interest, the port interest, at the same time not compromise the person's interest. So how do you bring all these various stakeholders onto one platform, make them agree, come to an agreement? That is where conciliation succeeds. Now, some questions may arise. Neutrality. The conciliator should be independent and jointly agreed upon by both parties, possible to take both side arguments, and you will have to keep it confidential because many things are revealed. The word government conciliator should be there, conciliator. Yes, if justified by force majeure and consistent with that, you can look into my books and find out how many people are engaged, whether I actually had them. Right? So this is something conciliation can do and actually determine the circumstances which happened during the COVID or during the cyclone or whatever it is, actual damage that took place. Did you claim insurance for that damage and now you're coming back to me and saying that, government also should give me. All these things we took into account while deciding the outcome of the case. There are few more case studies if you are interested, but otherwise we can, leave it to the question answer session. Should we go into the case studies?
Students,
It's, they're voting the rates.
So this case study, there was a tug. How many of you are aware of tugs? What is a tug? All of you should be aware. What is a tug? Tug is that small vessel which,
Yeah, somebody can, stand and say, article, go it there.
you know what the tug? Huh?
Yeah, no.
How many of you?
tug is a small vessel which tows the larger vessel into the port or outside the port, right? So there was this case where the operation, manning and maintenance contract of a tug was given to a private party by a port. Okay. One of the conditions was dry docking. How many of you are aware of dry docking? What is dry dock? Anybody has heard the term dry dock? Dry docking is when you have to carry out maintenance and repairs of the ship by taking it to a dry dock, taking it on to a lift or something, and then maybe cleaning the hull or going ahead with other repairs and maintenance, etc. So when this tug went for this dry docking, they were trying to lift the tug. It broke and fell down and incurred damages. And because of that, it was out of commission for nearly 2 years. They had to repair it, etc. etc. Now, first the parties went for arbitration. Arbitration said that the private party is not responsible for the accident, and therefore they awarded a huge sum of money to the private party. Court went to court contested this award. Then litigation was filed. What we talked about, that once arbitration is done, there is a appeal then further appeal, etc. So government went to the court went to first High Court, and show cause damages were issued. But when it came to conciliation, we treated this as a force majeure because the dry dock was handled by a third party, and it was not due to the negligence of the parties involved that this accident happened. So we discussed and decided after hearing both the parties that it was a force majeure. We pointed out that the arbitration had certain flaws, and we gave them a solution which said there will be 3 phases. First phase will be normal operations before this tug actually met with an accident, and therefore there will be a normal operation phase where regular terms and conditions of the contract will apply. Second period was the dry docking and repairs period, where we gave as an exceptional period where the normal terms of the contract were suspended, but we determined certain costs which were incurred by both parties, and we gave them a compensation. And then after resumption of the operation, we said the contract terms again comes into operation. So the conciliation committee took an objective assessment of who was at fault, whether that party was actually at fault. There was a third party which actually did the accident. They also claimed damages. So we said that the party would claim back these damages from them. So like this, we went into the conditions of that particular accident, that contract, and came out with a solution, which the normal courts or the arbitration cannot. The third case study is about, liquidated damages were imposed on a contract which was for design, construction, supply, installation, testing, and commissioning of some floating jetties. Liquidated damages. Liquidated damages means some amount is imposed for delays. If you are supposed to put up certain things in about 6 months, but you take 1 year, then there are some damages which are imposed on the parties. So liquidated damages were imposed. Now the question here was, will GST have to be paid? GST is goods and services tax. Now whether the GST is also to be levied or not, which was a huge amount. Then additional expenses incurred due to site changes, escalation claims, all this came before us. So what did we do? We said the delays were attributed to external factors, including site issues, approval delays, etc. Therefore, GST was not applicable. Two additional costs, changes in site and scope led to unforeseen costs. While not directly covered in the contract, the additional expenses warranted evaluation. We evaluated the additional costs and awarded. And the original clause required a fixed 5% guarantee, bank guarantee, but CSC proposed staggered reductions based on ANC completion milestone. So this was again important from the point of view that had we gone to the courts or arbitration, this could not have been done. We went and gave a suo motu solution for both the parties to accept. Now, what are the takeaways from this case study? That clear contracts, when you design contracts, often the lawyer does not know about your domain. You are the experts in your maritime sector. And therefore, when you define the contract, precise definitions of responsibilities and contingencies in contracts are very important. This can prevent disputes. If you are very clear in the contract that this is what I need, okay? You cannot use terms which are used in other contracts into this contract and say, okay, it is understood. In maritime sector, it might have a specific meaning and therefore it has to be precisely defined. Secondly, the role of conciliation. The process demonstrates the effectiveness of conciliation in resolving complex disputes without litigation. Flexibility in negotiation. Both parties benefited from a realistic approach. Because if both the parties have said, no, this party says, this is the contract, I will go only by the contract. The other party says, no, I will not go by the contract, then this would never have ended. So a realistic approach is required. Okay, I will not take more case studies. So what has the government done? The government has actually formed a 4-member conciliation and settlement committee in October 2021 and given it legal powers that it functions under Part 3 of the Conciliation and Arbitration Act of 1996. And that act provides that settlement agreement has the same status and effect as an arbitral award under Section 30 of the Arbitration and Conciliation Act, which means once the settlement agreement has been signed by both parties and authenticated by the conciliators, it becomes as good as an order which is enforceable in the court. No further appeal or litigation lies against standards. So far, about 96 cases have been referred to us, out of which we have signed agreements in almost 43 cases. We have been successful. And another 20 are under process and they will be settled soon. 32 are under discussions and consultations, and only one case so far has been dropped. So totally 96 cases in the last 3 years. And what is unique feature of this CSC is the fee is success based. What it means is in normal this thing, for each hearing you get a money. You heard that famous movie dialogue, Tariq pe Tariq. That the lawyer is interested only in getting the next day because he will get his fees. And longer the litigation takes place, more fees you will get. But in this conciliation committee, it is success fee. If you succeed in getting a settlement, you will get money. If you don't succeed, no money. So it is in the interest of the conciliator not to prolong matters, but to finish it and get some money. So this is the first thing. It is success fee based, success based. And secondly, it is settlement based. You cannot charge anything that you want. Whatever is the settled amount, a percentage of that subject to a ceiling. That is alone you will get, you will not get more than that. Second is, it is time bound. 9 months is the time given in normal circumstances for completing a conciliation. Maximum you can increase it by 3 months. If 12 months you are not able to bring both the parties to a settlement, then it has to be given up and they have to be told to go to the courts. So the costs are lower than arbitration or litigation. And finally, no forum shopping. You know what is forum shopping? I will look for a judge who will be favorable to me. I will see that the case goes only to that judge. Here, they cannot search for such people. People have been selected for their neutrality and for their impartiality and integrity, and you have to go only before them. So there is no, scope for going from court to court searching for a judge who will be favorable. So what are the range of issues which we have dealt with in the CSE? Default due to land acquisition, interpretation of the license agreement, change of law consequences, including change of cargo, liquidated damages, design of concession, determination of tariff surplus deficit, determination of LD, license fee during COVID, determination of annual lease rental, responsibility of obtaining statutory approval under lease deed, accidents. Wide range of disputes have been referred to the CSE, and CSE has been successful in dealing with this wide range of subjects with credibility. What should we do now? It is not, if you see in 3 years, 96 cases have come to us. And I told you why it doesn't come to us. Because people are reluctant, they are not aware. So many other factors I told you already, the challenges. So one is, people like you who are going to enter the industry, you should be sensitized that these methods exist. These are faster methods, efficient methods which we can adopt. So cultural sensitivity training program for the ADR practitioners. There should be a forum which also trains the arbitrators, the mediators and conciliators. Community outreach and education, inclusion of community and government leaders in this process. Showcase success stories. Customize the ADR processes to a particular domain. Even within the shipping domain, not all subjects can be under one conciliation. Specific sectors could be carved out and specific panels can be created. Local ADR centers. There's only one ADR in the shipping ministry. It could be localized. And of course, finally, government support and endorsement for the process. Because everyone today is scared. They say, if I send it to this, what will happen? Will there be questions raised? It should become part of the litigation procedure in government, that you have to go through all these procedures before you go to the court. Court is the last resort. They are already overburdened. So we should not go and get stuck in the courts. This should be within the litigation policy. So as a policy recommendation, I think we should be able to recommend to the government that we need a support and endorsement of the government for such alternate dispute resolution mechanisms. The way forward is that standardization is crucial to ensure consistency and predictability in the application of mediation and conciliation processes. Procedures have to be standardized and agreements facilitate the enforcement of settlements. Court and legal authorities are more likely to recognize and enforce agreements that adhere to established standards. This is again another policy recommendation I think you could take note. Standardization also enhances the legitimacy of conciliation as reputable dispute resolution methods and instills confidence in stakeholders about the fairness and reliability of ADR processes. And uniform standards help establish benchmarks for competence, ethics, and procedural fairness among practitioners. So I think these are areas of policy which we could probably recommend. This is the way forward. Develop standards and guidelines, accredit and certify through programs, professional associations and oversight bodies, continuous training and professional development, a uniform code of ethics, case management guidelines, feedback and evaluation mechanisms, and finally, collaboration with academic institutions like the IFU, who would probably be the right body to take up such recommendations to the government. So finally, I conclude with this that mediation and conciliation represent transformative approaches to resolving disputes in government contracts, and practical experience demonstrates their ability to deliver efficient, cost-effective, and amicable solutions while preserving relationships. As the case study reveals, the success of mediation and conciliation lies in their adaptability and focus on collaborative problem solving, making them indispensable tools in the realm of government contracting. So basically, this is all I had to share with you. If there are questions, I'll be happy to answer them.
I have one question. Thank you so much for the very comprehensive presentation on ADR, which is actually being promoted as the best means of resolving conflicts and disputes. My simple question is, the committee dealt with 95 cases. I just want to know what was the average time taken, or what was the quickest and the longest case?
We have a time limit of 9 months, I said,
Yeah,
and none of our cases have exceeded the time.
so on an average.
On an average, it would be maybe 3 sittings. Depends on when we, within a 6-month period.
Have you solved anything in one sitting?
Very, very rare because it takes a lot of documentation to be provided to us by both parties. And most of the time, the courts are found lacking because these are all old contracts. The oldest contract we settled was 25 years ago the dispute arose and it was still pending. And we could settle it in about 6 months.
Out of the 95 cases, the majority of them to look which court is that.
No,
Sir,
all courts, all.
Also,
Some courts are still reluctant to send cases to us. But many of the progressive courts, JNPT is one which is very, very progressive. You have Chennai court is also quite progressive. Cochin has referred a few cases to us. But many courts just don't want to.
apply to minor courts,
Minor courts have not come to us.
but can.
It can. We have in fact gone into policy matters also, like general policy for replacement of various types of equipment and ports. Whether it should be replaced on a time basis or whether it should be on the life basis. So these are things because it was an economic waste because we put down very standard things that at the end of 5 years you will change this equipment, at the end of so many years you will change that equipment. But the life of the equipment was still there. So we have given guidelines to the government for acceptance that not only how to evaluate the remaining life, but also its valuation of the life. If we accept this, then a lot of policy changes can come about, which would be more economical for the entire country rather than, scrapping equipment every 5 years or 10 years for the contract says. Of course, we put into this thing not only the residual life, but also the safety certification that has to be done so that to ensure that the full life of the equipment is taken.
Yes, Sir, conciliator still, they are appointed by government only, ministry. So the private party still, they'll have that reluctance, no, sir. They will not
That's
be.
what I said. Not all of them are government servants.
But appointed by government or ministry. So that.
No,
that
by
reluctance
the
will-
Indian Ports Association.
That is one. Second, can
And it is
AI be?
voluntary.
Volunteer.
So government doesn't say that you have to go. Unless both parties agree and come before the conciliation committee, we don't have a case.
And one more, can AI come and play? Since there is no human involvement and there won't be taking a side, can in future conciliators can be AI?
Need to develop AI in, there are lot of softwares available for arbitration now. Where all the processes at least have been put onto a system where automatically the arbitration processes are done by AI. Case management systems have also been developed where AI has been deployed. But the final decision will always rest with the human being. They can tell you that, okay, in such and such case, such and such decision, or you don't have to go through those volumes. It can give you but here in conciliation, it is not that process which is absolute frozen. You can give and dispute, then you can refer to these guidelines, which were issued in so and so years. There are different years on which these guidelines were issued. So like that, the training has to be given both on the process side and also on the resources available side, and then how do you actually draft the settlement agreement? What should be the format of that? All this can be given as a training package. Not on how to decide the case, but that will depend on the facts of that case. Right?
Sir, my question is, suppose there is a case that has been already due to the courts to resolve, and consider that there has been a lot of delay in the case, and thus there has not been any solution. Is the court or the private sector still eligible to approach a conciliator or a mediator in this case, or
Wonderful,
will they have
wonderful
to?
question. There have been cases where orders have been issued by courts but found unenforceable because the party did not have the means to enforce it. So what is the solution? You go back to the court and say, Honorable Court has given this direction, he is not fulfilling it, so take action against him. Right? Here, they come to conciliation and say, I'm not in a position to do it. So both the parties then agree, in spite of the orders of the court, we are agreeing to give up certain this thing and for the continuity of the project. Sometimes we have said, withdraw from the court's account. Sometimes we say, keep the court proceedings in abeyance. So they go and inform the court that, sir, we have now decided to go for conciliation. If it fails, we'll come back to you. So keep our case on record. We will finish this process and then come back to you later if we are not satisfied with the conciliation process. So once the conciliators are able to get them to an agreement, then they go back to the court and say, this is the settlement agreement which we have reached here. So we are now withdrawing the case. So all kinds of possible solutions are there, which, you will have to find out whether what suits you best.
Sir, because we said we already have a well-established solution system. So will ADR which is a parallel system, will it undermine the relevance and significance of the judicial system?
The judicial system itself is overloaded. Right? This ADR mechanisms and the ADR Act was brought in because the judicial system is overburdened. It's taking a long time and they are not able to concentrate on the more important cases from the less important cases, etc. They take a long time. They have acknowledged that. So they themselves have actually set up these mediation panels. High Court has a mediation panel. Every High Court seems to have such alternate dispute mechanism, where they themselves refer certain cases to the, because in the judicial litigation, it is only the judge who has to decide. The judge is not an expert in that maritime sector. He cannot call for an expert and say that, okay, as a witness, he can call. But detailed consultations with the private sector domain expert cannot be done in a litigation. Whereas this allows you in arbitration or conciliation. You can call an expert and talk to them about the maritime sector. They can give the inputs which are technical in nature. You can take into account those technical inputs and then decide the case. That is the advantage of this alternate dispute against a straight jacketed litigation. They can go only on points of law. They cannot go into technical and other aspects. They can go into the contract. They can say, okay, these are the terms, you failed in this, you failed in this. This is the judgment. But they cannot really go into the technical issue.
So first of all, because thanks for coming. If you have a session. Today's session, we understood the importance of ADR, advantages, price. But my question is, what's limitations or drawbacks? Why people are reluctant in going through ADR?
I presented the challenges in one of the slides. Challenges are basically people are unaware. Both the private parties as well as the government organizations are unaware of this alternate dispute resolution. Number two, ADR has not established itself. It has not become standardized. That's why last slide I said you have to standardize the process and make it a part of the regular litigation mechanism of the government. We have to insist that alternate methods should first be exhausted before going to the court. Court should be the last resort, is what we should bring about as a policy in the government. Then you have to create the infrastructure of more such conciliation panels, training of conciliators, awareness among the public through these methods of alternate dispute resolution. So then only this will really take off in a big way. 96 cases in about 3 years is not a great record, but we have made a beginning, and we hope that if further policy changes are brought about, this could become very effective means of dispute resolution.
Thank you, sir.
So I have one question.
Yes.
Let's take a major project where one of the parties involved is government. Second is a private agency. In most of the cases, it happens that the private agency will have many subcontracts, and there'll be other players also. So when it comes for conciliation, and when the decision or the verdict is given by the CSC, and it is as per the act, it is binding on both the parties. Does it also no, it doesn't trickle down to the other parties who have a separate contract with the private agency? Subcontractors.
Depends on the circumstance. We
Or
had one case where the main contractor was a conglomerate of many subcontractors. We actually had discussions with each of the subcontractors and got the settlement agreement, which actually listed each of these subcontractors and the liabilities that they will have to incur. Because when we say that, okay, we have settled for such and such amount, it means they have either taken a haircut on some, they cannot arbitrarily, pass on to their subcontract. So we brought all of them on board, and they were all signatories to the circular. Right. So that, it is enforceable, otherwise it is not enforceable. Right. This side is more active than that. Pittapuram. Shall we conclude?
Yes.
Thank you very much. You've been a lovely audience, and I hope you take away something from this lecture. And it would be a great pleasure to come back for any other session to the IMU. My sincere thanks to the Vice Chancellor, the Chancellor, and others, Co-Chancellor, and others, for giving me this opportunity to come for you. Thank you very much. Thank you.
Good afternoon, everyone. On behalf of everyone present here, I would like to express our sincere thanks to Dr. Chandramouli for delivering an insightful and engaging section on alternate dispute resolution mechanisms in the court sector. Dr. Chandramouli, you are deep expertise in the subject, the clarity with which you explain the complexities of maritime conflicts and its resolutions have provided us with invaluable knowledge. We truly appreciate the time and effort you have taken in making this lecture impactful. I would also like to express my gratitude to our Vice Chancellor, Pro Vice Chancellor, Registrar, Controller of Examination, Deputy Registrars, and officers who gave their approval and support for this lecture to take place. Without your encouraging, this event would not have been possible. Your commitment to fostering knowledge sharing and practical learning opportunities is greatly appreciated. A heartfelt thank you to the Director of Chennai Campus, heads of departments from School of Marine Engineering and Technology and School of Maritime Management for making the arrangement so that our students can attend this session. Your continued support in promoting educational initiatives is truly commendable. Lastly, a big thanks to you, all the students, scholars, and other participants who attended and engaged in today's lecture. Your participation and enthusiasm are what make such events meaningful and successful. Once again, thank you all, and we look forward to seeing you in future events. Thank you. Some refreshments are available outside, so please.
Sir, just a minute, sir.
Thank you for presenting and I hope something. We look forward to more next time I'd like to hear more. But I appreciate some of the questions asked. Really very good.